So what we'll do today is just go through the black letter law, child sexual abuse. You've got some criminal cases, parent protection cases, some termination parental rights cases, and then the child sexual abuse hearsay statute, 233, 81, 82, 83. Somebody stop me if we go, I don't know, beyond like by 10 past 2 or so when we're not finished, so I can assign roles for the exercise on Thursday. So they're not in any particular order in your materials. And I think your number one, which is not my number one, but that's okay, is Commonwealth v. Collin. Okay. So you want to look at it along with 233, 81, 82, and 83 were enacted, was legislation that was enacted sometime, I think it was in the late 80s, early 90s, to allow out-of-court statements of child sexual abuse victims under 10 years old. Keep in mind when we do the case study on Thursday, it was an older case and that statute had not been enacted, but we're going to, just for purposes of, so we can get into the statute too, we'll assume that it was enacted and that the middle child Jason is the one whose statements that the statute would apply to. So 233-81 is for criminal proceedings. 82 is for your civil proceedings, and that includes termination of parental rights, divorce, and then 83 is the section of the statute that includes the care and protection proceedings. So Commonwealth v. Collin was actually one of the first cases that construed, actually the first case that construed 233-81. And it actually, the opinion itself and the holding of the case didn't have much to do with the actual, with the statute itself, but with expert opinion. But the SJC, in the Collin opinion, talks about the new statute and gives some parameters, for judges in the future to use 233-81. Somebody just tell me what the holding that pertained to the expert was, and we'll quickly get that out of the way. Remember, an expert testified in that case? What was wrong with that particular testimony? Nick?
It was going to substantially influence the jury.
I can't hear you, I'm sorry?
It was going to, the testimony, if allowed, was going to substantially influence the jury's decision about whom to believe. So that's why they said the judge committed reversible error by allowing the doctored opinion testimony that Donald and Ned were sexually abused. And
Wait, tell me more about this, Jeremy.
What they were, what I got out of it was, what they said was her testimony that the child Ned was sexually abused, being based in large part on his statements to her, was essentially a statement vouching for Ned's credibility. So she was vouching for his credibility by telling the court what he told her. So they were basically using a medical professional to vouch for the juvenile's credibility.
Besides that,
so it's hearsay.
Well, we'll get to the hearsay piece of it. But what do you know about expert opinion and how Elizabeth?
Well,
and you might have encountered in an evidence class.
I don't know if I'm articulating this right, but it was more or less she was giving her opinion as opposed to what she's an expert in the field she's in, like that's appropriate.
In my opinion, she gets on the stand basically says, in my opinion, these child victims were actually sexually assaulted by the defendant. And you can't do that. That's the judge's ultimate decision to make, right? And you're going to hear more about this in the context of child sexual abuse, not only that, but rape cases, for example. It's okay, for example, for an expert on child abuse to say that a child exhibits the characteristics of child battered, what's it called? I'm sorry, there's battered woman syndrome, battered child syndrome. But what's not okay is for an expert to testify that a particular defendant fits the profile of a child batterer. So you've got to be really careful, when you're, Dan thought I wasn't on for some reason, I am, right? You have to be really careful when, it's the Commonwealth, it's the state, when you're using experts. Now, the court then went on, and this is even more important. I mean, keep that in mind because we'll get into, you may see other cases dealing with expert testimony of child sexual abuse. What did the court say about the what was then the newly enacted statute 23381? What procedural safeguards did you have to have? John?
Well, in order for the witnesses' hearsay statements to be introduced, it has to be corroborated by other evidence, independent evidence.
Okay, that's one piece of it. Corroboration, it's like the fourth factor. Remember, the court outlined like 4 factors, again, because what are you balancing here in terms of, first of all, what's the definition of hearsay? Anybody?
Any out-of-court statement ought to prove the truth of the matter asserted therein, unless.
Don't do the unless. That's the definition of hearsay. Unless would be either exceptions or something that's not hearsay, right? So a child who says, Daddy put his ba-ba-ba in my ba-ba-ba, right? And if that's sought to be introduced by social worker, cop, doctor, mother, grandmother, right? That's an out-of-court statement to prove the truth of the matter, that the child was sexually assaulted by a caretaker, defendant, etc. You now have, this statute is actually one of the exceptions, and it's a statutory exception, again, for children under 10. But it's balanced with, right, what are the rights of defendants? Constitutional rights, right? Rick, I did that before, didn't I?
Yeah.
Okay,
It's
Rick,
okay.
Rick.
Are you still looking for the 4 requirements?
Oh, I was, yeah,
The
give me the
defendant-
4 requirements,
the defendant has
but
to
wait, and give me the rationale for the 4 requirements.
Well, it's to get around the hearsay, is to provide the defendant the opportunity to know what information is going to be provided against him in court. So they have to make him aware of what the hearsay information is. And you give him an opportunity to respond to that.
Yeah, the Commonwealth has to give notice, right? This is what we're going to be doing in this case. We're going to be seeking to introduce this child's statements pursuant to 23381. So number 1, the defendant. But why does the defendant, before we even outline those 4 factors, why does the defendant have these rights? Bill? William?
I mean, I was going to the confrontation clause.
Absolutely, right? The confrontation clause. The right to face-to-face, and we'll get to that later on as well with the U.S. and SJC cases that you had to read towards the end. So notice, Rick.
Yeah. All right.
What's the next one? And this is all the burden on the Commonwealth, right?
Yeah, the Commonwealth must show by more than a mere preponderance of the evidence compelling need for use of such procedure.
Yep.
And I can't find the last 2.
John gave the last one, which is corroboration.
To determine the reliability of the child.
Absolutely, the reliability. Now, if you look at the statute as well, the first part of 81, section A says, again, the adequate statement of the child after 10 can be admissible. And you'll see this language in all 3 sections. Offered as evidence of a material fact. More probative on the point for which it is offered than any other evidence, okay, fine. The person to whom the statement was made testifies, of course. Police, for example, in the case study that you're going to do, both the policewoman and the social worker, their statements were the department was seeking to introduce their statements that Jason told me such and such and such, Alicia told me such and such and such. But again, they're, under this statute, if the statute applies, that particular person has to testify. And these are the important guarantees in terms of what William just said, the defendant's confrontation rights. The child is unavailable, the statement is reliable. So with section 81 and 82, and we're gonna look at the Quentin case afterwards, the proponent of those out-of-court statements has to meet those tests, unavailability and reliability. Has to give notice to the defendant, it has to show that there's a compelling need for the procedure, again, keeping in mind the defendant's, obviously, constitutional rights. So again, that's all that Colin is. It was a case that came up shortly after the statute was enacted. It came up on the expert opinions testimony being inadmissible because it was improper opinion testimony, but the court then clarified at that point the new statute. So keep that in mind again when we do the case study, because Lee, the father in this packet, if you started to go through it already, is his children are not only the subject of the care and protection case, but he's also criminally prosecuted as well in the case regarding the neighbor child as the victim, as well as his children. So out-of-court statements become particularly important for the criminal context as well as the care and protection context. Now, what's the next case you have? Is it custody of Eleanor?
Yeah.
Okay. Again, so going back to this, this testimony of experts, right? What was wrong with the particular evidence that the court heard in custody of Eleanor? Custody of Eleanor is obviously not a criminal case, but it's a care and protection case, obviously, involving child sexual abuse. Anybody want to help? Yes.
What information do you want?
All right, tell me what you know about Eleanor. What does Eleanor stand for?
Oh, actually, it was about a standard of review in a permanent termination of parental.
The standard review, okay, so what does the SJC say about the standards that should be followed in these cases?
In the absence of any physical evidence or corroboration of sexual abuse, it cannot be said that parental unfitness was proved by clear and convincing evidence. So the standard should be clear and convincing.
Okay, that's the standard of trial, but what standard does the SJC use or the appeals court use when mothers and fathers and children appeal these cases? So you just cited the standard of trial, the standard of proof, right?
Yeah.
Then it goes to appeal, and what do the appellate courts look at in order to determine, Nick has his hand up?
I think it's clear and convincing proof involves a degree of belief greater than that.
Okay, that's what William just said, which is great,
Oh, I thought it was
which is great, but it's the trial court standard. Now you have a party appealing, and what are they arguing about? What was wrong with what went on below? Jeremy?
Was that where they said the evidence presented a slender and therefore insufficient basis for the finding of the mother's unfitness? Is
Keep
that what
going,
you're talking
keep
about
going, keep going, because there's a magic language that's an appellate standard of review.
The judge's finding in a custody proceeding must be specific and detailed so as to demonstrate that close attention has been given to the evidence, and such findings must prove current parental unfitness clearly and convincingly.
Okay, and in what instances will they be, will that decision and those findings be overturned? When a judge does what? When a judge is what, John Paul?
I don't know whether it was the de novo, like. if you
It's
have-
actually not de novo, because the court isn't looking wide open at the facts all over again. It's a more of specific standard in reviewing the trial court judge. And you're gonna kick yourself when I say it. Clearly erroneous. So the court, yes, and you know, it's funny that you said de novo. The SJC says that appellate review in custody appeals is not done to assess the evidence de novo. So we're not reviewing the evidence all over again, but we're looking at the judge's findings and were they clearly erroneous, and whether they proved parental fitness, as Nick and William have said before, by clear and convincing evidence. So that's one piece in terms of the importance of Eleanor, set the standard of review. How about the evidence of sexual abuse? What was wrong with that? And it goes to what we just discussed before with the previous case on evidence.
That because there was no physical evidence when she withdrew her statement, it couldn't be corroborated.
Okay, there was that piece of it, the one allegation of inappropriate touching was later withdrawn, there was no corroboration. What about the judge's reliance on profile evidence, and what is that? And again, that is inappropriate to do, because why? First of all, what is profile evidence? You're gonna hear that term in a lot of these cases. What's
I mean, just
profile?
honestly, it
In both
sounds-
criminal cases and child sexual abuse.
It just sounds like you're kind of assuming based on how this guy or woman, whatever, engaged, that without even really knowing, you're just kind of stereotyping.
Yeah, like this person, for example, this person fits the characteristics of a sexual predator or a sexual offender. This person fits the characteristics of a domestic abuser. This person fits the characteristics of a child abuser. You can't do that, but you can certainly look at experts in the development of children. This child, fits the child who is the victim, fits the characteristics, or looks like he or she may be suffering from child battering syndrome, battered woman syndrome, etc. So that piece of it is important too in considering and talking about child sexual abuse. So again, it all amounted to that it wasn't enough. It wasn't enough in terms of, you were all right at the beginning when you said there wasn't clear and convincing evidence of the parents' unfitness because of those reasons. The third case was Carlos, adoption of Carlos. So now this one is a little bit different because it's a termination case. This case had a lot of history. I previously used to have the appellate version, appeals court, and went back up to the SJC at one point, and that's what you're reading today. Why do you think this case is important in your reading? Besides that it's a child sexual abuse case.
It basically sets out the standard to which a parent's right to the custody of his or her children could be terminated.
What's
So,
that standard?
Well, the custody of the children may not be terminated under the Care and Protection Statute or the Adoption Statute without clear and convincing evidence that the parent is currently unfit to further the child's best interest.
What does the court say about then this is important. One of the reasons why this case is important. What does the court say about the difference between a care and protection case and a termination case? which this was. What is the difference from what you've read so far between the care and protection case and termination of parental rights case? Sharon?
Was it the unwillingness of the parent?
I'm sorry?
The unwillingness of a parent to do anything, and that's why you terminate? But in this case, the mother was,
Well, not just the reason that the state may change its, goal to termination, but what are the major differences? I mean, you've all read your early family rights cases. Okay, what is the major difference between care and protection case, where a child is adjudicated in need of care and protection, and the termination of parental rights? Parents' consent to adoption is dispensed with. William?
I think the standard in termination is higher than that of care.
Well, the burden of proof is the same, though. Clear and convincing evidence of parental fitness. But, John Paul, what's the effect?
I just going to tell you what is the difference that they mentioned in a case, not just my own opinion.
Yep,
I think
yep.
because in a care and protection, they said they could review every, they have an opportunity to review every.
Under 119.26, after trial, you lose as a parent. You have a right to what's called review and redetermination every 6 months. So say, last week when we discussed the domestic violence, say, and mother is the one that is asking for review and redetermination. Maybe she's gotten some therapy regarding battered women syndrome. She is not, living with the abusive spouse anymore. She comes back on a review and redetermination to get custody of her children back. Even though the department got custody after trial, her rights haven't been terminated. And furthermore, 29B of Section 119, the court itself holds hearings every year. Those cases are not really over. The court says, in this regard, and that's what John Paul, I think, was looking at, there is a significant difference in impact on both the parent and the child between an award of custody and a care and protection proceeding, which primarily addresses only current fitness of the parent, current fitness, reviewable every 6 months, and the extreme step, and they put that in quotes, the extreme step of terminating the parent and child's relationship. In determining, and I'm not going to read the next part because that goes to what the what black letter law rule came out of this case, and what the court said it would consider regarding this mother, because this was a termination of her parental rights. You know what I'm getting at? So the department had been working with the mother for a long time. In fact, like I said before, this case had gone up, the appeals go back down again, then back up again, and finally the SJC says, first of all, we're talking about an extreme case, so this is how we're going to be looking at the 210s, the 210 section 3, the termination of parental rights cases. What are we going to consider where C&Ps are current parental fitness? 210s are, they're current parental fitness, but we're also going to consider what?
That it might be only temporary, and that they might be able to get better. Or not better.
Landmark, we're going to consider future parental fitness. Future parental fitness. And that's an appropriate, it's a factor, not that we're going to hang our hat on it completely, but because it's a termination of parental rights, we're going to look to the future. And in Carlos, you had a case where, the mom was not in the early stages acknowledging, again, because the dynamics are so close, the domestic violence, child sexual abuse, not acknowledging the sexual abuse. And when the case came to trial, she had made some baby steps in terms of the service plan. and the judgment must analyze the parent's character, temperament, capacity, conduct in relation to the particular child needs, age, etc. So the court, again, can look at the reasonable likelihood that at trial, that her, what looks to be her unfitness or his unfitness might be only temporary. So again, it's the difference is the extremeness, except for appeal, possibly an overturn on appeal. If the judge in juvenile court or the probate and family court under 210 section 3 dispenses with the parent's need, consent to adoption, you've lost everything. Custody, visitation, giving your child anything in your will, inheritance, etc. Everything, you've lost. Okay, let's look at the custody of Jennifer. I know the case that dealt with adequate statements, and this case was decided before the statute 233 was enacted. So this case discusses some exceptions to the hearsay doctrine that was attempted by the state. So what hearsay statements of the daughters were allowed by the trial court?
Teachers, social workers.
Yeah.
Psychologists.
Yeah.
Yeah.
And how they, under what exception to the hearsay rule were they admitted? They were admitted at trial. It was acknowledged they were hearsay. They were adequate statements, often evidence proof the truth of the matter asserted that children were sexually assaulted. But they were admitted because why? What was the exception to the hearsay rule under which they were admitted?
State of mind.
State of mind. What state of mind? And how does it play out in a care protection case?
I thought here, in this case, the state of mind was the fear of the being kidnapped. They look into the statement of the fear itself. It's a state of fear. And it wasn't said, the case says that it wasn't said just that to accept the truth in that matter, in that regard of being kidnapped, but just the state of this child fearing that he's going to be kidnapped.
And if you can show that the state of mind, and the state of mind can be material in a care protection petition, but what does the judge have to be careful about when the judge I'm going to allow these statements in, not for the truth of the matter asserted, but for state of mind. Then how do I use these statements? Because the judge in that case, obviously, they used the statements inappropriately, right? How did the judge use them inappropriately? Why was the judge wrong? The judge was right in allowing them for state of mind, Sharon.
He used it as proof of critical past events.
Relied on, first of all, remember what the standard is, right? Clear and convincing evidence of parental unfitness. Okay, I'm going to let them in for state of mind. All right, now the department has met its burden. Well, what is the clear and convincing evidence if you only let those statements in for a state of mind and there's virtually no other evidence? Again, we're going to encounter that problem in the case study as well, because Alicia and Jason allegedly make statements initially to the social worker and the cop, and then the department and the district attorney is seeking to use those statements. There's no physical evidence of rape, so there's no physical evidence. The children recant their statements, so that's pretty much all the state has. And I think, and I forget, more than one case says this, that in many cases, the only people that know that abuse has occurred is the victim and the perpetrator. So if you don't have the victim's statements, what else do you have? other doctrine that was discussed that actually changes, and we'll discuss the later mass cases. So we have a doctrine in Massachusetts called the fresh complaint doctrine. And it meant literally that, at first, it meant that a person could testify about the victim coming in, quote, complaining, right, to the reporter, whether that reporter was, again, cop, social worker, medical personnel, mother, grandmother, etc. And later on, when you look at the Emerald case, there were tons of fresh complaints, fresh complaint testimony. The Commonwealth with, I believe it was the King case, I didn't give you that case to read, but you have the Aviles, if I pronounce the right case, at the end of your packet. The Commonwealth, Massachusetts, then introduced a new doctrine to sort of make things, I guess, more streamlined. At the first complaint. So rather than have a multitude of reporters, one after the other, saying, the victim said this, the victim said this, and blah, blah, blah. First complaint means only the first person that the victim talked to about the rape or sexual assault can testify. But you'll see that in the later cases. So the court mentions in Jennifer that this wasn't, in fact, even fresh complaint testimony. And again, it's mainly quoted for the proposition that, you can't rely on just, one exception to the hearsay rule, being the state of mind exception, for example, in this case, and then hang your hat on that to prove the entire case. You're not going to meet the standard of clear and convincing evidence of current parental unfitness doing it that way. Now, custody of Mikhail was not a sexual abuse case, but it is also a case that deals with hearsay statements of children. Who wants to talk about it? And I call this the Kate Crossing case. I just do. I don't know. It's the Kate Crossing case to me. Do you remember case? In the old days, by the way, all the cases used to, because you can't use the actual names of the parties, right? So Mikhail, is a pseudonym for whoever the child's real name was. But in the old cases, you would see things like care and protection of a minor, custody of minor 1, custody of minor 2, you'd see petition of DSS, blah, blah, blah. And at some point, the appellate courts caught on, and they started to give, pseudonyms to the cases. So anyway, Kate Crossing case, somebody tell me about it. It was a dad that was the caretaker, right?
It was an immigrant family from, I think it was France.
Okay.
Came from. They were living in a local YMCA.
Mm-hmm.
There were allegations that the father was abusive towards the mother and the kids, verbally, physically. I believe some of the staff had seen, some of the altercations between the two. They'd heard, threats, they throw the kids out the window. Yeah. Then they left the Commonwealth and then returned like 6 years later. They had a couple more kids. And again, multiple abuse cases, multiple 51As reported. One was a father beat the mother with a broom. Let's see, what else do I got here? For several months, the family lived separately from the father. DSS assisted the mother. Mikhail, he was absent from school a lot. He started to regress in school. He started acting out, having problems, focusing at school, things of that nature. There was at one point the father actually had him like barricaded in the house.
Yeah.
The police had to remove
The
him from the
ultimate
second story.
emergency removal, right?
Yeah,
From a
the
second
police
story
had to remove
window.
him from like a second story window.
What about the statements of the children that were admitted in the care protection proceeding? How were they admitted? Again, they were out-of-court statements. So what was the hearsay exception by which they were admissible? And why was it okay in this case, but not in the Jennifer case that you just read?
I think this was the hearsay statement of children that made to and reported by professionals. This time it's the statement.
But they were what was the purpose of the statement? So obviously, once one goes to testify and the other attorney says, objection, that's hearsay. No, Your Honor, I'm putting it in because it's,
Is it because there were conditions affecting children?
Was there no-
what specific exception to the hearsay rule? Under what exception were they allowed?
Well, here it said the children's statements may be admissible when used for diagnostic or treatment purposes.
Diagnostic or treatment purposes, what else?
Mental state.
Mental state, the same exception as in Jennifer.
Yes.
However, there was enough other independent evidence. All the horrible facts that Jeremy just repeated amounted to clear and convincing evidence of parental unfitness. So there was other evidence besides just, again, you can only use the out-of-court statements for the purpose that they were introduced, not to prove the abuse itself. What about Oscar? Oscar was one of the children. This particularly might be important in terms of, again, the case study where you have our case study, the young child Jonathan in our case that we'll do on Thursday.
On this particular.
I think his name was Oscar, right?
Yeah, it was.
Yes, there was no convincing. Oscar did not meet the burden because they said there was no clear and convincing on the part of the Oscar that he was abused.
Who said that?
Isn't it the custody of the youngest child? But that was actually the counsel. I'm sorry, that's the counsel. That's the counsel for Oscar who said that it's a statement.
That was the argument. What did the appeals court rule on that particular issue? So you have, and this is important because many times you have, a family, right? And there's allegations of abuse and neglect. And there may be specific allegations regarding some children and either not so specific or even an absence of allegations. And that was the case with Oscar. What did the court say? Nick, you had your hand up.
Well, I was going to say that there was no justification for removing him because
What
Oscar
is the
hadn't shown
appeals
any
court
signs
rule?
of.
Again, that was one of the arguments, and you could make that argument as defense counsel. Katika?
I'm not sure. I was just gonna say that they said that just because there's no evidence of it right now doesn't mean that it can't happen in the future. Looking at the parental fitness, they can easily predict future performance by the parents.
Yeah. John?
I was going to say, it's in determining parental unfitness, a judge may use past conduct to predict future ability and performance.
Yeah.
And you don't have to wait for, as they said, disaster to happen.
Famous
first.
quote, a judge does not have to wait for disaster to happen. Again, perfectly fine for what you all just stated, that you're defense counsel, so if you were to say Jonathan's and you, in our case study, and you think that Jonathan should remain with his father, you would vehemently, oppose the department's petition. Look, there's no evidence of abuse regarding this particular child. But that doesn't mean that the court won't consider it.
But here they actually, if I may say,
Yeah.
I think the rule that it's just, it was all the other children had enough contact with the children, that's why they manifested the abuse more.
Exactly.
But for this particular child, they said the fact that he relatively little manifested relatively little emotional damage is that his limited contact with his parent caused him to endure comparably less hardship. So it was just he had maybe not
For
enough
whatever
contact.
reason,
Yes.
he wasn't involved as much. And I don't know if he was the youngest, I don't remember.
That's what they said.
Was he the youngest? And that typically happens. Again, I'll refer back to our case study that we're gonna do. the only allegations of sexual abuse, assault, rape are regarding the victims, Jason, Alicia, and the neighbor Justin. None regarding Jonathan, the youngest child. So keep the Miguel case in mind on that proposition. So care and protection of Martha. So you have some more hearsay evidence now. Why was this harmless error? What hearsay evidence did the court hear and from whom? Who's the person that testified? Nick?
This Martha and Donna's psychotherapist.
Yeah.
The judge admitted the testimony, but the mother objected to the introduction of these statements because they proved the truth of the matter asserted. And she said they were hearsay and they shouldn't have been admitted for the substance. And the judge agreed and sustained her objection and admitted that the statements solely for non-testimonial, non-hearsay purposes.
I'm sorry, what did you just say at the end?
The judge agreed sustaining her
When you
objection.
say the judge, who do you mean?
Judge?
The trial judge?
I'm assuming the appellate judge?
Or you're talking about the SJC?
Yeah.
Just be clear, when you're saying the judge, I don't know if you mean the trial judge that allowed the testimony initially, or the SJC that reviewed whether the trial judge was wrong or right. And remember, clearly erroneous was the standard. So there was error, right? On the, at least of that particular issue on the part of the trial judge. However, the adjudication of care and protection was affirmed, so somebody tell me why. So the trial judge committed error in allowing the evidence, the hearsay evidence by the psychotherapist. However, the case doesn't go back down for a retrial because why?
The judge before him, the conviction for sexual abuse and the photograph depicting those abuses.
There was overwhelming,
Right.
right, evidence. The parents were also criminally convicted,
Yep.
but in that case as well, so very important. So the criminal case ended before the care and protection case. So the criminal convictions went in, as well as I just said, all of this other evidence. So again, it amounted to clear and convincing evidence of unfitness. So the case couldn't be thrown out just because the judge erred in allowing the hearsay testimony of the psychotherapist. Yes, that was error, the SJC says, but it's harmless. It's harmless error. Okay, you have your next 233 case with Rebecca. So care and protection of Rebecca was decided in 1994, shortly after 233-83 was enacted. And by the way, when you look at the statute, you'll see that 81 and 82 look very similar. And 83 is like a short little paragraph, right? So let's take a look at the statute as well as the Rebecca case. So what was the hearsay evidence in Rebecca?
It was an out-of-court statement made by Rebecca and Ruth and Arnold.
Rebecca and who?
Ruth, is it Ruth?
Yeah, yeah,
And Arnold.
yeah.
And
Who introduced the hearsay statements of the children?
Their third set of foster parents.
Okay. A little convoluted, right, with the different foster parents. So what happened with respect to, at least with, Rebecca and Ruth, with the first and second, were they disclosing anything to the first and second?
Or whether they mentioned anything?
Right, right. So Elizabeth just said it was the third set of foster parents that were the reporters, and the department seeks to introduce Ruth and Rebecca's statements that were made to the third set of foster parents. So my question is, what happened, or if anything, did Rebecca and Ruth disclose or not disclose anything to the first and second set?
Is it bad? The mother abused them? Their brothers?
Yeah, yeah, they said nothing, no, nothing happened. All of a sudden, they're at the third set, yeah, something happened, blah, 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 right?
Yes.
What is the standard under which those statements are admissible or not admissible?
Substantive evidence is
So look at the statute where, the statute is just the one paragraph, right? What are you seeing in the statute that indicates, okay, this is if I'm the judge in a care and protection case, I'm gonna look at section 83 and determine whether these adequate statements are gonna come in or not.
Totality of the evidence?
Are you reading from part of the statute or from the case itself?
The case itself?
Okay. Let's take, do anybody have 83 in front of them? It's short, so I can read it if you don't. So, 233-83 says custody hearings, adequate statements describing sexual contact admissibility. And as I said, 81 and 82 are long. They're more than a page. 83 is just this paragraph. And all it says is any adequate statements of a child under the age of 10 describing any act of sexual contact performed on or with the child, the circumstances under which it occurred, or which identifies the perpetrator, and then there's reference to the statute, shall be admissible. Shall be admissible. And here's the important language in terms of the standard. Provided, however, that the person to whom the statement was made, or who heard the child made the statement testifies, so you have the reporter testifying, and the judge finds that the statement is offered as evidence of a material fact and is more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable effort. Now, how does the SJC construe that last provision? And that's the key right there. The judge has to find the statement is offered as evidence of a material fact, more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable effort. So, number one, what guidance does the SJC give on construing that section 83? And what does the SJC conclude about the out-of-court statements of Rebecca and Ruth? the statements. At least regarding the mother.
The actual statements, like,
Yeah.
sexual touchings, that I think was the statement made to the first appearance, about the inappropriate touching of those children.
Yeah, but what kind of touching, what was the mother doing or allegedly doing?
Sexual,
Rough medicine.
Yeah.
So they,
And there was evidence that the children had suffered from scabies infections. Okay, so that was those were the statements. What does the SJC say about these statements, and what guidance, again, further does the SJC offer in how you construe this hearsay exception in care and protection cases?
so there was evidence of touching, however, it was, they're gonna remove them not because of the sexual abuse, because of,
Say that again?
they're not gonna, rule their unfitness because of sexual abuse, but it was inadequate. Says, however, the finding the mother had committed and condoned sexual abuse for her daughters.
I'm not following you, John.
Said there was admissible evidence raising doubt about their mother's ability to provide an adequate home for.
Were those statements admissible under section 83?
I think they were admissible.
I'm sorry?
I thought they were admissible.
The SJC rules they're admissible?
That's what I thought.
Why does the case go back down?
Does it require?
I'm sorry?
Does 83 require availability or unavailability before?
Okay, so let's consider unavailability before we talk about reliability. So the court specifically says that the unavailability requirement is conspicuously absent from section 83. And here's where the court also says that it's the balance between the competing interests, again, the due process rights of the parent, the protection of the child. There are generally no witnesses to an act of abuse other than the victim and the perpetrator. Corroborative evidence might be lacking. But then it goes on further, and you mentioned reliability. It says that implied in the statute, however, so that language that I just read to you, the SJC is saying that implied in that language is a requirement that the judge actually assess the reliability of such evidence in connection with deciding how much weight to accord to it. So you had, again, the foster mother that said, the kids said, Mom had touched their genitals and rubbed medicine in their privates. Then you have Dr., what was his name, Clinton, that during therapy, Rebecca also told them mother had touched in her private parts. But then again, you also have the evidence that the children had indeed suffered from something that could be explainable in terms of touching the private parts. So there were problems with how those statements came in, even though the standard is so low for allowing statements in a care and protection case. So essentially, it's the SJC telling you that even though it doesn't quite say unavailability and reliability in section 83, the judge is really, making a decision about how reliable those statements are. And if the judge is relying on evidence that it's sort of improperly considered, then it could be that there is not justification for clear and convincing evidence of parental unfitness. It's very weird about the putting medicine on the privates, because one of the, I should wait till we do this on Thursday, but I can't help it. There were all kinds of problems with Lee and the case regarding his children. At one point, he lived with a girlfriend and the girlfriend's son, and they moved out and also filed a 51A against him that he, and nothing came of it, but that he allegedly had touched her boys' private parts. And he had alleged at the time that he was putting poison ivy or some kind of medicine on his private parts. So that whenever I read this case, I remember one of the allegations in the case that we'll be doing. So again, the Rebecca is used for the proposition that, even though 83 looks like it's real easy in terms of getting in out of court statements and parent protection cases, the judge still has to really be convinced that that evidence is going to be reliable, because it's hearsay, it's out of court statements, and you have to balance the rights of parents, the whole triangle, the parent, child, state, in terms of allowing those out of court statements. Now, Quentin is your next case, which dealt with Section 81, because it was an adoption case. It has the same standards under the statute, 23382, of unavailability, reliability, corroboration. So obviously this is a parental termination case. Pretty much identical to Colin in terms of the test. So if you're involved in a case that could be termination of parental rights, an adoption case, and the state is seeking to introduce out-of-court statements of children with sexual abuse, children under 10, what other requirements, again, and it's just a repeat pretty much of Colin in terms of the factors. Anybody want to give us the factors, and we'll just note them again? Same factors as Colin.
Notice,
Yep.
give notice, and show a compelling need.
Preponderance of the evidence for the procedure, right?
Yep.
Keep going. So I'm going to give, if it's the adoption case, and I'm the petitioner and I'm DCF, I'm going to give notice to the parents that, notice in terms of, to the court as well, that the department is seeking to introduce these statements. I then got to prove by preponderance of the evidence that there's a compelling need for this particular procedure. So there's like a hearing as to that, where parties can argue whether or not these out-of-court statements should come in. Then there's a separate hearing on what?
Determination of the
On
child's.
reliability of the state. So this is the court still considering, it's like a separate, almost ex parte, because it's with the attorneys themselves, for the court to make the decision whether the statements should come in. Separate hearing on reliability, and finally corroboration. By the way, when you look at the 81 and 82 and the findings of unavailability, what you frequently see, obviously, first of all, as to unavailability, no witness is available if they're dead, or if there's, some really physical, mental illness preventing them from coming to court. Then sometimes you might have a witness, in this case a child, exerting some sort of privilege. So that might be another reason why the child's quote, found unavailable to testify. Another reason is a lack of memory. I don't remember. The fourth reason that the child is absent for whatever reason, can't find him. The department says, I have these out-of-court statements, but can't find the witness, the child. And last, and this is probably the one that, not last, but fifth, the one that's most often used, so if the child has a clinician, a psychotherapist or whatever, that would present expert testimony that should this child testify, that would cause severe psychological trauma to the child. And that's pretty obvious because in these cases, the perpetrators are not strangers, they're family, they're parents, stepfather, boyfriend of mother, etc. So that's usually a reason why the department or the Commonwealth is seeking to do out-of-court statements. They don't want to subject the child to the trauma of testifying. And many have said that when children are abused, in particular sexually abused, they go through trauma twice, right? One is the abuse, and the other is the next is the abuse of the court system. And again, with reliability, both 81 and 82 talk about the separate hearing, where the court is convinced that the statement was made in circumstances that indicate a specific indicia of reliability. So you need that unavailability and reliability. It's on the record, it's in the language of 81 and 82. It's not in the language of 83, so a little bit easier in the care and protection cases for the out-of-court statements to come in, and obviously harder for termination because it's the extreme case of terminating parental rights, and of course harder for criminal cases where the parent defendants would likely be incarcerated. Adoption of Tina. Hearsay statements again. The only, was this the one that, I was gonna skip one of them, I can't remember if this was the one. Yeah, it's basically the same, in terms of Quentin, it's just following Quentin, the same requirements, the notice preponderance of the evidence, the separate hearing, the cooperation, so we can kind of skip that because it stands for the same rule of law as Quentin. And actually it was adoption of Daisy that I was going to totally skip. All Daisy is Daisy was under 10 when she made the statements, and then she was over 10 by the time the case proceeded to trial. So the statements still come in, because 233, 81, 82, 83 are about out-of-court statements of children, so it's when they're made, is the child 10 or under. Okay, now we get to the remaining group of cases with Marilyn v. Craig that deal with criminal child rape, child sexual abuse, some not familial incestual cases, but cases where a stranger or someone that's not a parental figure has sexually assaulted a child. So what does the Supreme Court decide? What's the issue before the court in Maryland v. Craig? And what particular constitutional right of the defendant is involved in a case like this?
I didn't read those because on my syllabus it said they were for Thursday.
Okay.
So I did not.
Is
I
anyone-
just
okay,
missed
all right. You can read them for Thursday, but I'll just briefly go through them and then I'll sign the rolls. So, when we're talking about child witnesses, there's been a history of, obviously, the whole reason for 81, 82, and 83 being allowed is to prevent kids under 10 from entering the courtroom and having to testify against their mommy or their daddy who's done this horrible, unspeakable acts to them. So, many times the courts try different things to accommodate child witnesses. So in Maryland v. Craig, the child witness testified outside the defendant's physical presence in a one-way closed circuit television. The Supreme Court ends up finding that as long as you have a finding of necessity for a procedure like this that accommodates child victims, that the courts could look on a case-specific basis to allow, again, balancing the individual defendants' right, confrontation rights. So if it's a federal right you're talking about, and it's child victims you're talking about, it's possible that you don't need the actual face-to-face that we used to think about initially, at least with the confrontation clause, right? Confront the witnesses against you, blah, blah, blah. But you really gotta be able, before you submit to before you, if you're the state and wanna introduce a procedure like that, that you really show an absolute necessity for that. And so again, the Supreme Court ends up saying face-to-face is not an absolute constitutional requirement, but we're gonna look at a case-specific finding of necessity. Unlike Mass, which I'll get to in a moment, you have to read the Emerald cases, and there were 2 of them. Some of you may remember that this arose as a result of the investigation of the Fells Acre Day School in Malden back in like the 80s, where children started to report to their families that they were sexually assaulted at the daycare. In particular, Chucky Emerald, which is the son of Violet Emerald, who ran the daycare, and there were not only the introduction of like the child-sized tables for the children that ended up testifying in trial, and also the use of what I mentioned before, the fresh complaint testimony, where you had, mothers, parents, etc., testifying as to what the children told them. So it was out-of-court statements, but they weren't offered in evidence to prove the truth of the matter because they were offered as evidence of fresh complaint testimony. What's important with fresh complaint and later on first complaint, is what we follow now in Massachusetts, that, okay, so you can have the person, I'm the cop, and this person just came to me to complain he or she was raped. I can testify because it's not hearsay. I'm just testifying that that person complained, right? Fresh complaint. But my testimony will really only be allowable if the victim also testifies, right? Because my testimony is merely going to be, corroborating ultimately hers or his. What was the problem, and you'll see the problem in our case study too, is that the children, Jason and Alicia, refused to testify. So the department really had a problem with, all right, well, we can't now, can we introduce it as fresh complaint? Back then it was the fresh complaint issue. So that was the Emerald case, and later on, in the second Emerald case, the defendant was arguing that his face-to-face confrontation right was violated. And the court found, the SJC found that, even though it was violated, well, first of all, you waived that right because you didn't say anything back then. And this absence of face-to-face didn't create the likelihood, and that was the standard of substantial likelihood of miscarriage of justice, another standard that you see in criminal cases that is a reason for the court to say, yeah, you made a mistake, but it doesn't rise to this to this level. Commonwealth v. Johnson was the case in Massachusetts that ruled that Massachusetts giving more rights to criminal defendants. Yes, you need the face-to-face. So that screen, that TV, et cetera, whatever it is that you're gonna use, is gonna violate defendants' constitutional rights, at least according to Article 12 of the Mass Constitution. Both Johnson, Bergstrom was the earlier case, the statute that allowed for electronic means. They both stand for the same proposition that in Massachusetts you need face-to-face. So you have Maryland v. Craig, the federal standard, that there may be some instances where you can get away with no face-to-face with children if you can absolutely find necessity, but you have Massachusetts that affords defendants more rights, and defendants do need that face-to-face confrontation under Article 12. And last, see, I'm looking at the time, okay, I'm good, it's 10 past. Aviles is a good, really read Aviles because it's a nice explanation of this first complaint doctrine that overrode the earlier fresh complaint doctrine. The child in Aviles first made statements to mother and later to grandmother. So the court talks about the later statements, and again, the insistence in Massachusetts on only having one person testifying as to the out-of-court statements, one person being the first complaint person. So I want to, who didn't get one of these? I mean, it's the top page of your packet, but you can write on this because I want to assign you rules. Sharon, can you do that? Just Sharon? Oh.
I think I have this.
Oops.
Is
Yeah,
that the last?
but I handed this out so you can write on it.
Okay.
So what we're gonna do is sort of a round table where all these attorneys and legal personnel involved in the case are getting together to see if there's any possibility of coming to some sort of agreement on both the care and protection case as well as the criminal case regarding these children. So I'm going to need some DCF attorneys, a DA, a court-appointed investigator, guardian ad litem, Alicia's attorneys, Jason's, Jonathan's, and Lee's attorneys. I probably would like to double up on Lee's attorneys, DCF attorney, and district attorney. Let me just see. Anybody missing today? No, everybody's here, so. One court-appointed investigator, one guardian ad litem, one definitely for Jonathan. If I do 2 DAs, 2 DCF, 2 for Lee. Let me do 3 for Lee, because he's involved in both cases. Okay. Preferences, so I'd like 2 volunteers for DCF, 2 district attorneys, and then one investigator, 1 GAL, 1 attorney for Alicia, 1 for Jason, 1 for Jonathan, and 3 for Lee.
I'll be
Any
a
takers?
DCF attorney.
Elizabeth? Anybody else want to be one more person for DCF?
Jeremy and I be DA.
Okay, wait a minute, hold that thought. Anybody for DCF? John Paul, we
I
good?
can be this year.
Okay, so Elizabeth and John Paul, and then Jeremy and Ryan.
There's Kevin.
Jeremy and Ryan, no, Rick.
Rick.
court-appointed investigator is going to be sort of summarizing what he or she has done, not necessarily arguing a legal position. I'll come back to that for a minute. Then we have a guardian ad litem. So the court-appointed investigator actually does kind of recommend, reunification if that's possible. You'll read you can read the reports. But the guardian ad litem maintains that the children need some sort of protection from their father. He's currently unfit. Termination might be the appropriate, so they're kind of at odds with each other. That's the guardian ad litem. Sharon? Okay. Sharon's the guardian ad litem. And then Alicia's attorneys and Jason's attorneys. Let me just tell you that where I say your role is to advocate Alicia's and Jason's wishes. So in this case, what happened was, as soon as they really walked out of DCF offices that first day, they recanted and their position, and they were older children. Again, we're gonna say for purposes of the statute that Jason was like, 9 3/4, so that we can argue the statute, and Alicia's about 11 or 12. So they're maintaining that they want to stay with their father, so that's your position if you represent Alicia and Jason. Jonathan, because he's young, you have to do it different, and you can read my rule of counsel stuff, that's for reading, you have to advocate what Jonathan would want if he was mature enough to say so, because obviously he's using the substitute judgment approach. So any takers on any of those? And, yeah,
I'll volunteer for the investigator.
investigator? Nick, okay. Carla?
I could be Alicia's attorney.
I'm sorry?
Alicia's attorney.
Carla?
I'll be Jonathan's.
Jonathan's attorney, John. Anybody for Jason, anybody for Lee? I have 4 more
I
openings.
was Jason.
Okay. And Lee, so that leaves Anthony, and who else? Tika, and William. Okay. So what are we doing on Thursday? I'll try to negotiate it. In the real case, at one point, we did get together, and I'll tell you later on what happened with that negotiation. But both cases are open. The case regarding the criminal prosecution of Lee. By the way, the way this case started was with the 51A report that came in as a result of Lee appearing in court regarding the alleged molestation of the neighbor, Justin. Well, at some point, Justin and his parents, you can't make this up, you know how they say you can't make this up? Justin and his parents moved away, and that case got all processed, nothing, that was gone. So what was open then was the criminal prosecution of Lee for the alleged sexual assault of his own children, Alicia and Jason, and then the care and protection, again, where the department was thinking about should this be a termination, but it was a care and protection case regarding his children. So that's the case that the 2 cases where the parties are coming together and seeing if they can be resolved before trial. 119, I forget which section it was now, 119-51, something like D, no, I totally, ABC. Somewhere in section K talks about the information that goes to the district attorney. So the way that the district attorney learned about Lee, Alicia, and Jason was because of the department's 51A and 51B report. So under 119, if a child has been allegedly sexually assaulted and the department is doing their investigation, they report that, they send that 51B report to the district attorney's office. They send subsequently to that assessments, service plans, so information is going to the district attorney's office. So keep that in mind in terms of, you know, how much the district attorneys knew before they decided to indict Lee for the sexual assault of his children. Elizabeth?
Oh, my only question was, that's the start of the criminal procedure then, right? Once DCF sends the 51B to the DA, and then they take it and run with it?
And run with it is the right word, yeah.
Okay.
So at some point, and I can't remember if it was after Jason and his family just fled, the DA's, the district attorney's office indicted Lee for the sexual assault of his children. So those are the two cases that we're considering in the packet. And so you have a bunch of stuff in there. Keep it confidential, even though I've redacted stuff. You have the police report, social workers report, temporary custody orders, the report to the DA that I just mentioned, the court-appointed investigators report. There's nothing by the GAL, so Sharon, you're just, I'm sorry, you're just in favor of termination of parental rights. So, if you got.
I just wanted to know which one you signed me up for.
What did I sign you up for?
Lee's attorneys.
Okay.
I'll send this out with the roles, that way the online students can know who's playing the roles. And I have extra packets. If you know any of the online students, I'll send them a message too. The packets are outside my office for the online students to pick up too. I'll see you Thursday.